Yes.
My Lord, the position on the undertaking is we've adapted a form of words from the standard, from the precedent given in the White Book, which I'll hand up to you if I may. We've provided it to the other parties. We've had some objections back, and I'll explain to you what the objections are and what our position is, if that would be convenient.
So I am going to be policing the wording of the undertaking in the most important procurement case this century.
Well,
how are we in this position? I'm genuinely baffled, Mr. Cole.
So, well,
genuinely baffled.
What this wording does is to...
No, I understand that, but why are we in a position where I've called this in as an application for permission to appeal? There was no breath in the original application that undertakings were an issue. It's quite clear from the correspondence that they are, but I simply don't understand why we're in this position.
So, what we have done in this wording is to give effect to paragraph 125 of the judgment, which we were content with. We haven't challenged. The judge said, had she been minded to maintain the suspension, she would have required an undertaking to the Commission and to Allwyn in the usual terms. We have given effect to that, as I'll show you in this wording. What is coming back from the other side is that we're being asked for an undertaking not in the usual terms and to go quite far beyond what the judge said.
That was apparent from the solicitor's correspondence.
Well,
the position is the suspension runs out in 25.5 hours' time. So at 4:30 tomorrow afternoon, the Commission can enter into the contract.
So you say, my Lord, that it was apparent from the solicitor's correspondence. In fact, the letter which Miss Davis showed you of the 1st of July asked us to give effect to paragraph 125 of the judge's judgment.
Yes.
Pending the appeal, and that is what this wording does. Can I ask you, perhaps before you look at that, to take up page 2904 of the White Book, volume 2.
To which, sorry?
2904. And it's an extract from the web document that Mr. Moser referred to, a precedent injunction.
2904.
Yes. So just above the
garnishee orders.
I'm sorry, I'm using Mr. Moser's White Book. I hope it's not the.
It's. I've got 2022 as.
I've got 29.
290. Volume 1.
Yeah. No. What have you got?
No. Volume 2.
Volume 2.
Sorry,
my Lord. Yes.
Sorry.
Yeah.
So just above the heading, halfway down the page, you see standard wording. If the court later finds that this order or carrying it out has caused loss to the respondent and decides that the respondent should be compensated for that loss, the applicant will comply with any order the court may make. And we have adapted that with paragraph 125 of the judgment in mind to the form of words which you see that I've just handed up. So I can ask you to take a look at that, please.
Right.
Now, the two objections that we've had so far, and of course there may be others, firstly from Allwyn, who say that this undertaking is only given by the two Camelot appellants and not by their parent company, Ontario Teachers Pension Plan.
Sorry, say again?
The objection is that the undertaking is only given by the claimant Camelot companies, Camelot UK and Camelot Global, and not by their parent company, the Ontario Teachers Pension Plan.
Yeah.
And Allwyn's point, and I'm sure you'll hear from Ms Davis in due course, is, well, we can't be sure that Camelot have enough money to cover our losses. Now, there has been an ongoing dispute between the parties about whether the Ontario Teachers Pension Plan can be expected to give an undertaking or to stand behind Camelot's undertaking, notwithstanding putting aside any arguments as to whether that's necessary. But can they be expected to when they are excluded from the confidentiality ring? And they haven't been able to be shown any of the...
How can the court decide that?
Well, the issue of whether they ought to be in the confidentiality ring is before Mrs Justice O'Farrell on the 27th of July.
Yes, but you've got 25 hours to keep the suspension going, so that will be too late.
Well, my lord, it will be too late if you accept the proposition that the court...
No, I just want undertakings that are agreed by the parties.
Well, my lord,
Because all of this should have been done weeks and weeks ago.
But then, well, we're in the position where no matter what the demands that are made on the other side, and of course it's in the other side's interest to make this sort of demand, that I have to agree to.
The difficulty is that this is something that you're telling us for the first time. But in fact, it's something that it is a point that has arisen as between the solicitors some time ago.
That's right, my lord. And on the Ontario Teachers Pension...
So how can the court be in a position to decide the dispute when it's only hearing about it for the first time now?
So on the Ontario Teachers Pension Plan, there has been correspondence, and there was some argument before Mrs Justice O'Farrell, and where the parties have ended up is that Allwyn won't agree for the parent company to be shown the details of the claim.
Right.
So that is going before the judge on the 27th of July.
When you say the details of the claim, you mean the confidential material in the Allwyn tender?
No, because we haven't seen the Allwyn tender. You might think that that's the only truly confidential information in this case.
Right. So what is the information that can't be seen at the moment?
So the two aspects. Well, there's a huge proportion of the critical material in the claim as to what the claim's actually about, what the claims are. But the two particular things that we can't tell our parent company about are firstly the detail of the principal claims which are made against the Commission, because they focus on wording in the Commission's evaluation, which is said to be confidential.
Yeah.
But secondly, we're not able to show our parent company the evidence of Allwyn insofar as it details their potential losses.
Yes.
in the event of the suspension being maintained and Camelot and the Commission succeeding at trial. So we are not able to tell our parent company what the potential amount of the undertaking is that they're being asked to stand behind.
Right.
Now we hope and we anticipate that will be sorted out by the judge on the 27th of July. We have applied to extend the confidentiality ring so we can at least give that basic information to our parent company. And then, of course, there is a standard procedure for an application to be made for an undertaking to be fortified. If a party to whom the undertaking is given believes that it's not going to be good enough to cover their loss, then there is a procedure for applying for the undertaking to be fortified in the future. But as of today, we respectfully submit we cannot. Our parent company simply cannot give an undertaking. It's not what the judge required, and our parent company cannot give it without being told the basic details of what it might be in for. And with respect to my learned friends, it is been an absolutely exorbitant assertion of confidentiality in this claim, which has had detrimental impacts in a number of different respects, and this is one of them. We're back before the judge on the 27th when we hope to reduce the scope of the confidentiality claims and to get our parent company admitted to the confidentiality ring for certain purposes. So that's the first objection that's been intimated. The second objection, believed by the Commission, they say, well, this undertaking doesn't cover any shortfall in contributions to good causes. Now, as I've said, this is the standard form. And can I just ask you, I've mentioned it.
It's the standard form that deals with the standard situation, which is where a respondent would suffer loss directly.
So I've mentioned it, but can I just ask you to take up 125 of the judgment, please? The judge says, if the court were otherwise inclined to maintain the suspension pending trial, this issue could be addressed with the imposition of a condition in the order that Camelot and IGT provide an unlimited undertaking in damages to the commissioners will, within the usual terms required, then be a matter for the claimants to decide whether they're prepared to take commercial risk. Now, the judge heard argument from the Commission as to what the scope of the undertaking was that was being offered by Camelot, and that was the basis for the Commission's, part of the basis for the Commission's arguments on adequacy of damages. They said the undertaking's not sufficient to compensate the loss suffered because, e.g., it doesn't cover loss to good causes. Answer from the judge is what she would require was an unlimited undertaking in damages, which is what we've offered, to the Commission and to Allwyn in the usual terms required. Now, it's not said that the judge made some error of principle here. I'm
not following this. Do you say that 125 excludes good causes?
It excludes shortfall in contributions to good causes because it is an undertaking in damages to the Commission and to Allwyn and not to any...
Can you help me, I think, just to make sure I'm not going to head off in the wrong direction? What's the mechanics for money going to good causes? Is it a pure contractual obligation, or, in other words, that, if you like, Camelot collects in all the money and then has a contractual obligation or an obligation under the license to pay a sum to good causes, or is there some ring-fenced trust mechanism? Is it just a contractual mechanism? It's important because I think it then may bear upon the question that we're heading towards, which is, what do you mean by Allwyn's losses? I mean, if Allwyn's losses include an amount which will cover what it is then required to pay to good causes are built in. This needs to be clarified, but what's the actual mechanism?
So, first of all, I'm absolutely certain that Allwyn's losses don't and couldn't possibly include a loss to good causes.
Well, my lord's just asked you why that is the case, and so could you answer his question?
So can I then take my lord to page 31 of the supplementary bundle, please? And this is from the commission skeleton below, where 81 subpara 4 on page 31, you see loss to good causes is a loss to the 12 lottery distribution funds and to the charity, sporting and community projects which benefit from lottery funding, not a financial loss to the commission.
No, I understand the commission never gets its hands on the money. The question is, how does it go through your client's hands?
Yes. So the way it works is that my clients take in the proceeds of the lottery. They're permitted to retain an agreed sum. I can't recall if it's a percentage or quite how it's worked out, but there's an agreed amount that they're entitled to retain, and then everything else gets paid directly into the
fund.
National Lottery Distribution Fund,
right?
Which breaks down into various.
But is that? And I'm sorry, I'm showing my sort of anorak sense as a company lawyer here. Is that through a simply debtor-creditor relationship, i.e. an obligation under the license to take in the full amount, and then an obligation to pay a sum equivalent to a certain proportion of it as a matter of obligation, in which case everything comes onto your balance sheet? If I was drawing up a balance sheet of the company, yes, it would be on it. Or is it treated as something which never comes onto your balance sheet, and if you like, is held on some form of trust?
Well, I think I know the answer to that, but can I turn my back for a moment, just to make sure that I... So, Lord, I can answer the question to the extent that it is a condition of the license that we retain a certain proportion or calculated in a certain way and pay the rest to good causes. I can't give you a definitive answer to whether it comes onto our balance sheet or not. I mean, we certainly collect in the money. We get the ticket revenues, and but whether there's an intervening trust or something.
The reason I ask you is because you're in the seat at the moment. I mean, I'm assuming that the same mechanism would apply to Allwyn if the hypothesis for this is that Allwyn is being prevented from getting the fourth license for a period of time, and then says, well, we have suffered loss because of the proportion which we would have been entitled to retain to cover our Allwyn's expenses and the like, in other words, our profit. But Allwyn would also have onto its balance sheet a sum which it then would be able to use to discharge a liability to pay it into the funds. And
right.
And now, if your intention, I understand your point, your intention was never to cover the part which it has an obligation to pay to good causes. So I understand that's what you say you shouldn't be required to cover, and the Commission says you should. What I'm just trying to understand for the purposes of looking at the wording is what's the actual legal mechanism by which this distribution to good causes takes place?
Yes. Well, I shall find out. What I can say is that Allwyn filed two lengthy witness statements detailing the losses that they might suffer in the event of the suspension being maintained, and they've never suggested that loss to good causes was a loss to them. Their potential losses are in additional costs that they may have if they can't do a transition plan as currently, and in some respect very, they say very substantial, but not suggested that the loss to good causes is somehow a loss to them. Similar, I will get you an answer to that.
Well, I only asked it to make sure that before this argument kicked off, I understood just how the mechanism works.
Yes.
I think for present purposes, let's put the mechanism to one side because it sounds like it's a question of wording.
Because your wording is loss, so it might be said that's sufficient, depending on the precise mechanism. But anyway, as you made clear, it's not the intention that loss includes the money that would be paid to good causes. Is that right?
That's not our intention.
Yeah.
Or indeed any differential which could be established to be the loss to good causes of the difference between having your client in the saddle or Owen in the saddle. I mean,
that's right. That's
we're actually
what we're talking about.
Yes. Yeah, we were actually talking about, on this hypothesis, it being established that Owen can generate more for good causes than your client. Or at least that is a possibility. Sorry, it's a possibility. So it's the incremental difference to good causes, isn't it? Because you are going to, on this hypothesis, somebody is going to be continuing to run the lottery and paying money to good causes until this is all resolved.
Yes.
So it's only the differential.
That's right. It's the differential.
Is that right?
Exactly.
No.
And there's I should say the Commission's case before the judge was that the fourth licence will generate more revenue for good causes than the third licence. So any delay in the start of the fourth licence, whoever performs it, they said, will be less beneficial for good causes than a continuation of the third licence.
Okay. So it's a differential that could be made up of two sources.
Yeah.
One, the nature of the licence, and two, the nature of the identity of the operator.
Exactly.
Right.
But it's the increment.
So what would happen to that loss if the challenge was unsuccessful?
Well, there may or may not be any such loss.
Well, this is all hypothetical, but please answer the question. What would happen to that loss? The answer is that loss would simply fall where it falls and there would be no compensation, even if the challenge was unsuccessful.
Yes, my lord, it is not our intention or was not our intention to offer to give an undertaking in respect of contributions to good causes. If, having heard the argument, the court takes the view that must be offered, well, of course, I will take instructions, but that was not our intention. So as I mentioned, the judge heard certain argument about the scope of the undertaking which had been offered by Camelot, and in the same document, at page 44 of the supplementary bundle, paragraph 100.
Does it matter what the judge had? The only place where the judge deals with this is at page 125, where she's covering the point if she was doing something that she didn't do. So I'm not quite sure where this goes.
Well,
she didn't do 125 because she decided that the suspension should come to an end.
Yes. Well, where it goes is both she took a view following argument as to what the appropriate scope of the undertaking should be, and no one suggests that that was wrong.
Well, you mean the one sentence in 125?
So in paragraph, can I show you paragraph 130 on page 44, please? Just a short reference. This again is in the Commission's.
Are you suggesting that we're bound by the content of paragraph 125?
You're not formally bound, but it is of some relevance, we say, both because that's what the judge thought was the appropriate undertaking, having heard a good deal more argument than and seen evidence that you haven't seen, but also because on the 1st of July, what Allwyn asked us for was to do what the judge had said would have to be done in paragraph 125.
Well, you made that point.
Yeah.
So we're now, it seems to us, being asked to go by the Commission's objection, being asked to go significantly beyond what the 1st of July letter said, and to do so on the hoof. And Lord, just to show you paragraph 130.
You are not on the hoof. You are 25 hours away from the suspension ending. So you can't pretend as if somehow this is all new and a surprise.
Well, Lord, what is new is that we're no longer, it seems, being asked to give the paragraph 125 undertaking. We're being asked to give a much broader undertaking. And if I could ask you to look at paragraph 130, what the Commission said wasn't covered.
Sorry, so this is back in the supplemental bundle?
Yes, page 44.
Yes.
The Commission has said neither Camelot nor IGT had mentioned the willingness to make a cross undertaking to meet potential damages incurred by the Commission, Allwyn and or the National Lottery and Distribution Funds. Estimated quantum of harm to good causes and tax revenues are set out in Tanner 3. So there was a hint there that not only should Camelot be prepared to meet a shortfall in good causes, but also to meet a shortfall in tax revenues, and then Allwyn's loss. And you see the figures there, which I'm not going to read out, including the quite startling figure in the final line of the paragraph.
These are very lucrative, these lottery contracts. This is your point at the very start of the day.
Yes.
Points which, speaking entirely for myself, I thought were well made. That this is a particularly significant and important procurement exercise.
Yes.
So the figures are, to my eye, unsurprising.
Well, and so far as Allwyn's losses are concerned, that is covered by the wording which I have provided you with. So my point is merely at this stage that having heard argument from the Commission that an undertaking ought to cover National Lottery Distribution Fund, tax revenues, and so forth, we ended up with 125. Now,
the whole point about 125 is it's one sentence. It doesn't specify the detail of what is or is not in it.
Well, Lord, it does.
I mean, you're asking it to bear a huge weight.
Well,
Even if it were binding, you're asking it to bear a huge weight. As it isn't, obviously, it can't bear very much weight at all. But I mean, she's simply saying that there should be a cross. If I was minded to maintain the suspension, there should be a cross undertaking, unlimited, in relation to the losses that they'd suffer.
To the Commission and Allwyn in relation to the losses they suffer, and that is the wording that I've given you. And
Yes, I agree. I thought loss would, because we had this debate this morning, I thought loss would include good causes. But you're very clear that it doesn't. Now that's good, because you've made it clear that your interpretation of loss does not include the money that would go to good causes. I find that surprising, but that's your interpretation. And you've shown us the evidence that shows that that was how it was being approached. But this whole exercise demonstrates why this is so much better done not in a courtroom.
Yes.
But what can I do? I'm simply here to help.
So, one...
Notwithstanding a position that some people don't seem to be wanting to be held. Anyway, there it is.
My Lord, I always want to be helped.
I wasn't actually thinking of you.
And as I say, my Lord, I've told you what our intention and our understanding is.
Yeah, no, that's
if,
good, because that has demonstrated that there is a difference as to what it might cover.
And if the court, having heard the argument, takes the view that it must cover shortfalls, good causes, then, as I say, I will take instructions and
Okay.
So
is that it on the order as it stands? Oh, sorry, the offer as it stands.
No. I've got one other point in terms of the practicalities.
Well, sorry, just before we go to practicalities, I mean, can you actually tell me, maybe I missed it, why as a matter of policy shouldn't the undertaking apply to good causes? I've heard lots of reference to what Mrs. Justice O'Farrell said, but why as a matter of policy, where there's an obvious third party who is potentially affected, shouldn't the undertaking cover potential losses to them in the same way that if, for example, you're granting an injunction and it's apparent that a third party is potentially affected by the grant of the injunction, the cross undertaking may be extended to them. I mean, it's in the little extract in volume 2 you asked us to look at. It's just over the page. What's the actual substance of the argument as to why it should or shouldn't?
Well, it is not common, or indeed we aren't aware of any previous example in the procurement context where the usual terms have involved compensating third parties. Generally, the third party involved is the unsuccessful bidder, and they come along to court, as you've seen, and the undertaking does.
This is the very particular nature of the lottery, is that it's, as you said right at the start, my Lord pointed out to you right at the start this morning, you emphasised the fact that it's very important because it not only generates money for the operator, but it generates money for the public in the UK, good causes.
Yes. Yes. But just as Allwyn has come to court to say we may suffer losses if the suspension is maintained, it would be open to any other third party to come forward and say we may suffer losses.
What do you mean? People who might benefit from lottery funding?
Well, that's
treat me as a person who might benefit from lottery funding.
That's one of the difficulties, is that we are being, or what is being said is that we should be offering an undertaking with effectively contractual terms to persons unknown. I mean, one saw the way the Commission put it in the skeleton. Everybody who may.
Well, it's not persons unknown, is it? It's the 12 funds that are. Is it 12 funds that are identified as the mechanism for distribution to good causes? I mean, they are the ones who get, as I would understand it, the sum of money calculated in accordance with the license, and then it's for them to dish it out. So it's actually, it's not unidentified people. They're the identified people who have then presumably responsibility under statute or otherwise for distributing money to good causes.
Yes. Well, and Lord, it may be, and I don't know for sure if it's the same person involved in each of these funds. Let's say it's the Secretary of State. I'm not certain. It would have been open to the Secretary of State who's been participating in this correspondence, and indeed in these proceedings by correspondence. It would indeed be open to the Secretary of State after today to come forward and say, I need the cross undertaking to be extended to me. But that hasn't been done.
I mean, what you've got is the Commission, who is, in a sense, responsible in the broader sense for ensuring that the lottery is properly run, making the point presumably on their behalf. I mean, is that? I mean, I'm sure somebody can wheel somebody in to say, yeah, I agree with what's being said on behalf of the Commission. Do we really need that? I mean, can we just get down to identifying the point of principle? Why, as a point of principle, shouldn't the cross-undertaking extend to the potential loss to the money, potential loss to the distribution mechanism, to the people who benefit from the distribution mechanism?
Yes. Well, Lord, I've made the points I've made about who we're supposed to be undertaking to. There's also a real, we would say, access to justice issue here. If you, the extract from the Commission's skeleton that I just showed you, which referred to good causes and tax revenue, cross-refers to figures given in Mr. Tanner's third statement, 482 of the bundle. Now we have a number of difficulties with these figures, which purport to estimate potential losses. The principal one of which is they appear to be absolute losses as opposed to losses caused by delayed receipt of additional sums. But it's obviously in the Commission's interest to make the sums look as large as possible. And if you look at the bottom line, gap in operation of the National Lottery, £8.1 billion. Now, as I say, we have great difficulty with those figures, and we put a statement in response. But, my Lord, no bidder, no entity is going to be able to challenge of an important competition such as this if they're being said, well, you need to put up a cross-undertaking of £8.1 billion.
Well, hang on, this is for, sorry, this is for the alleged scale of harm in various scenarios over 10 years starting from the end of the third licence. Sorry, we're not, I mean, I know legal proceedings occasionally grind precious slow, but we're not looking at the right number here, are we?
Well, this is...
The undertaking is to cover delay, losses caused by the delay from your grant of permission, if you get it, to your failing at the end of the day, if you do.
Yes.
And that's not 10 years. I mean, that's not 10 years, is it?
Well, that is what the Commission was intending to show. See paragraph 46, the previous page. And the argument, as I understand it, is, well, if you take in less at the start, that has a multiplying effect over the rest of the lottery, and you don't grow as quickly as you thought you were going to, and etc. But as I say, this is supposed to be a representation of what the costs of maintaining the suspension.
But doesn't what the Commission, I'm just looking at paragraph 49, I think, strange if I've not read this before, but isn't it paragraph 49 that sort of gives a much lower figure, potentially? I mean, sorry, big, but lower.
Well, as I say, my Lord, that they start with that 1 billion figure, and then they say that then has that effect is compounded. The loss of £1 billion in the early period is compounded over the 10 years, and you end up with the figure at the bottom of the table in the event of a gap in operation of the National Lottery, or I should say the third line is probably more realistic in terms of what might actually happen. Interim license, but these are still sums which no bidder is ever going to be able to countenance. They're wholly out of proportion to the profits that might be made, and if the law really is that that the bidder must stand behind money of that order, and indeed the impact on lottery duty as well, these decisions will be effectively unchallengeable.
But that again is one of the unique features of this case, that it's not about profit, it's about good causes. That's again the submission you made this morning. We can't ignore that.
Yes. And what's being said by the Commission today to my clients is, well, even if you say that we've made an unlawful decision as regarding which of the bidders is going to do the best for good causes, well, if you want to litigate that and still have a chance of getting this license, you need to put up money in that order.
But this is money that's payable if you're wrong.
If we're wrong.
The decision was lawful, but you've delayed it and caused loss as a result of a claim that turned out to be wrong.
Of course.
So you wouldn't be in that scenario. It's then a question of the compensation as a result of the wrong challenge.
But the point remains, there is an arguable case that this very important contract has been unlawfully awarded, and that there's been an unlawful misjudgment of the winning bidder's capacity to benefit good causes.
I mean, this situation can't be unique outside procurement disputes, where I mean, I understand your access to justice point. I mean, is there any? I can't off the top of my head think, but can you of any case that sort of takes the point that there may come a point at which the court says you don't need to provide a cross-undertaking in damages if it's too great an exposure, because it would deny you access to justice. I mean, I know there are cases where applicants who are performing a public function, for example, or an office holder function, give limited cross-undertaking damages, and certainly in the insolvency field that's the case.
Yes.
What I just can't remember the debate in those cases. But effectively, what you're saying is that there must come a point in time at which the court puts a cap on a cross-undertaking. But do you do that by reference to the potential beneficiaries of the cross-undertaking, or do you do it by reference to the monetary amount? Because what you seem to be doing here is that, as I understand it, it started out with a debate that you were asked for a cross-undertaking in damages to the Commission and Olwyn, and you originally said yes, subject to a cap, or at least there was reference to a cap of 50 or 100 million, I think. And then maybe I misread it, but the cap seems to have disappeared. But now you're facing another potential area of beneficiaries from the cross-undertaking. I mean, have I understood how this has gone?
So I'm sorry. There was never a cap. We had evidence to say that here's the money that we currently have access to. It was 50 million, and it's going to be 100 million.
Oh, okay.
And would be more.
Right.
And then that's what Lord Panic clarified at the last hearing, that it's not a capped undertaking we're offering. It's a
unlimited, but that was okay. Got it.
To to answer my lord's question on other authorities, it is certainly the case that the court will frequently order a capped undertaking. I don't have a particular case on access to justice in mind, but then we would go back to first principles. But it is, we would say, important to bear in mind that if the court is willing to countenance permission to appeal subject to this issue, then we will have established at least an arguable case in the public interest for the lawfulness of this appointment to be determined prior to it being made.
Is that right? Because what we're doing is considering whether or not you're entitled to permission to appeal on the judge's decision to lift the suspension.
Quite right.
As we discussed this morning, that presupposes there's a serious issue to be tried. But if we gave you permission and this was heard, what the decision would be whether Mrs. Justice O'Farrell was right or wrong to conclude that the suspension should be lifted. It wouldn't answer the lawfulness of the underlying procurement.
Well, I'm sorry, I perhaps didn't make myself clear. My point was, if you are prepared to countenance a challenge to Mr. Justice O'Farrell's ruling on lifting of the suspension, then it will be because you are persuaded that there is at least a reasonable argument as to there being a strong public interest in the legality of the ward being determined before it takes place.
It wouldn't necessarily follow. If we gave permission, it's because we thought there was a real prospect of success on the individual points raised, but which I think is a slightly different point. But in any event, even if you were right, we would still come back to the importance of the provision of undertaking.
You would, Lord, and Lord, perhaps I'm not making this clear, but the point I'm seeking to make is you will not give permission to appeal unless you see force in the argument that this award, the legality of this award should be determined before rather than after. If I'm wrong about that, which is my central public interest point, I won't get permission. But if you are contemplating permission, you will have recognised to some extent the public interest in legality being determined before awards.
Well, you put it another way, you say it's not just about access to justice for the challenger, but given i.e. your clients, but there may be a public interest in not shutting down an appeal, which there's a reasonable prospect of success by imposing too high a burden in terms of the cost undertaking, which nobody could ever be expected to meet.
Yes. Yeah. Thank you, Lord. And then finally, I just come back to the point I have. If my lords are not with me on the necessity of offering and undertaking to cover losses to good causes for the reasons that we've been debating, then I would like the opportunity to take instructions, and we are very keen to comply with any requirements which the court may say are necessary.
Okay. So it comes at the moment. It comes down to this. We'll hear from Miss Hannaford and Miss Davis in a moment. But at the moment, as your understanding, it comes down to those 2 points: the parent company point and the good causes point.
Well, look, there is one other point. I can deal with this when I make my submissions. There is one other point.
You deal with it when you make your submissions. But I want to hear from Mr. Moser, just in case he has anything to add, or do the same points apply again?
My Lord, I have no difference with Mr. Coppell on the wording of the undertaking. I would say 2 things about my Lord Justice Snowden's questions to principle. The first is really a point your Lordship has just made, which is that to impose so high a threshold on a case of this kind, and maybe it's unique, but there may be other cases like this, would be to create an inbuilt stifling mechanism in procurement cases where there is a suspension in play, in the case of what is otherwise a good appeal, and that would be unfortunate. I would
There
also...
aren't many procurement challenges where an element of the overall, quote, loss is contributions to good causes. Certainly in the waste disposal procurement that I've done, that doesn't tend to be a major factor.
No.
I may have been unlucky, but that is my experience. So I completely take the point that the figures are potentially enormous, and that of itself, in this case, might be regarded as having a potential effect on access to justice. I completely get that. But I think it may not be a sort of case on that particular point where one could extract a general principle.
But perhaps not. Perhaps not. But I mean, if one started down that road, taking the example of waste disposal and perhaps taking it slightly further than is entirely logical. But if one says, oh, well, in this case, it may well be that in the interim some terrible mishap will occur because of the lack of a new waste disposal facility, and waste will seep out into the estuary, and therefore your undertaking ought to cover any damage that might result to the locality from the seepage of waste. Yeah. Then perhaps that is not dissimilar to saying
Well, there would be issues of remoteness and foreseeability which don't arise here, because good causes is obviously a critical element of it. But I take the point.
Indeed. Well, actually, my Lord, that was going to be my other point, and I make it gently because we haven't got the authorities before us and so on. But on the whole, undertakings work on contractual principles, and so there are privity problems in respect of general remote third parties. If we don't have identified third parties to whom undertakings are given, they are not covered by undertakings generally. I mean, there are pharmaceutical cases, for instance, where undertakings are given by the pharmaceutical company.
Why don't you just, if we identified the 12 the 12 funds, I've seen the reference to them somewhere this afternoon, that there are 12 funds who are engaged in distribution of good causes, aren't they? Where the money is given to. I mean, they are contractually or under some regulation or license the recipients of the money. You must know where the money is being sent to.
But, my Lord, yes, but as a matter of reality, we're dealing, certainly as far as my clients are concerned, with
but the amount of money going to them is not fixed by who is on the other end receiving end. It's fixed by how much has been collected in and is available to go to them.
Yes.
But so you only need to look at that step.
Indeed, but we're dealing here with commercial players, at least on this side, who have to make these decisions. And I appreciate the court would say, well, so be it. They have to make complicated decisions.
Yeah. So I thought you were just making a point of unidentifiability.
I was. But I've moved on to another point, which is even if they could be identified, I was going to say no sensible CEO is going to underwrite an undertaking of such potential breadth. I mean, it would de facto be the end of. I mean, let's be clear. Certainly, as far as we're concerned, that would be the end of any chance of the suspension and the appeal going ahead. Certainly together, because that is an undertaking I submit we cannot see ourselves offering.
But is it
on an open-ended basis?
But is that because of the amount, or because of the identity of the recipient?
Well, both in a sense, because as this matter has arisen in discussion between your Lordship and my learned friend and myself in the last quarter of an hour, that is certainly not something on which I have instructions.
Yeah.
It's.
But if you don't have instructions, I don't suppose you could actually tell us that it won't be given?
Well, Lord, I'm speculating, but there it is. It seems extremely unlikely.
I wonder if my learned friend could clarify whether he actually has instructions to give an undertaking in the terms that Mr. Coppell has offered, because that wasn't available at 2:30.
Yes, I was going to come on to that, Lord, because it's actually the most important part of my submissions. We have the relevant instructions to agree the wording of Mr. Coppell's undertaking, because that falls within the scope of those who are available to us to give instructions. I said earlier, and I note my Lord Justice Coulson's response to it. I said earlier that those who ultimately signed it off were 6 hours behind us. I now wish they were 6 hours behind us. I gather they're 8 hours behind us. We're talking about Las Vegas time. They are, I hope, by now getting up and finding the relevant voicemails and emails. Entirely take the point.
So you have, sorry,
yes.
You have or have not the relevant instructions?
I have not the relevant instructions to sign off on actually giving the undertaking, although I have the relevant instructions on the words. And that is because the person who wishes to make that decision was asleep until now.
Right, okay.
Again, access to justice. We were under the impression we had maybe now 24 hours to do this. We would obtain the relevant instructions by, say, midnight tonight. A short extension.
Extraordinarily, you know, we do have other things to do in this court.
The court.
I know that procurement people think that we simply exist to provide a service to them as and when they have a dispute, but I've had to really carve out time and impose on my Lord's generosity that he is prepared to sit with me today so that two LJs rather than one can consider this important application. I had rather hoped that we would long be done and dusted by now, not that, oh, well, I've still got another 24 hours.
Lord, we had hoped that the court would not be troubled by it, because it would simply be a question of us getting the instructions, and the answer would be yes or no. And if it were no, well, that would be to our detriment. But if there is a proper appeal, I don't know what the court's decision is going to be, but if there's a proper appeal that we're entitled to, a short further extension I submit with apologies and regret, but I submit is entirely proportionate in that regard.
Well, at the moment, we see the two things linked. Even if technically they may be different, we see the two things linked because the whole purpose of the permission to appeal is to extend the suspension.
Yes.
Because nobody wants an academic appeal.
No.
So that is the position. All right. So your concern is the second of Mr. Coppell's concerns, namely the good causes point.
It is, but we are in agreement with Mr. Coppell on the good causes point, whatever the case.
Yes.
So the sign-off I seek is on the basis of not including good causes. I'm not in a position to say that we give an undertaking that doesn't include good causes either, because as I say, the person who wants to make that decision has not yet been reached.
But if that same person has not yet agreed to sign off on this, we can't rely on this as being the undertaking that you're giving. Well,
Lord, my instructions are that the lawyers who are here representing IGT have the instructions to agree such a wording. But we don't have the instructions at the moment just to sign off the undertaking, which is a matter that is above the pay grade of those who are here with me.
Sorry, there are two things. You did. I understand don't have instructions actually to sign,
Yes.
actually to give, full stop, period, anything.
Yes.
You have instructions to agree that this form of wording modified presumably to fit your clients, not Camelot.
Yes, and that's because...
But,
yeah.
but good cause is neither at the moment because it just hasn't been canvassed with the person who's asleep, or because the lawyers here...
It has been canvassed. I know my instructions on good causes. My instructions on good causes are that it is not our view that good causes are to be part of any undertaking. And that is not going to change.
Right.
And the wording, I can agree, because obviously we have discussed the wording before, and the wording, as per paragraph 125 of Mrs. Justice O'Farrell's judgment, is entirely standard. So I know the wording is fine.
Yeah.
I know what our position is on good causes.
Did she have argument on good causes before giving the judgment that she did? I mean, was the good causes issue as ventilated in front of her in the way it has been in front of us?
I can't recall. Well,
My Lord, I certainly spoke about good causes and undertakings and so on, but it wasn't ventilated in the way it's been ventilated today, because of course it didn't arise, because there wasn't an undertaking about which both Melinda and Miss Davis and I complained. And then, of course, there wasn't an order maintaining the suspension.
Yes, I mean, I'm okay, but I'm sort of picking up my Lord Justice Coulson's point this morning that, in essence, what we're looking at here is if the decision had gone the other way.
Well, then I imagine there would have been a debate between the parties, and, if necessary, in front of the court as to the form of the undertaking.
So there wasn't actually a full...
No.
In fact, my learned friend is, of course, absolutely right. And I see what she said. It's at page 158 of a transcript that we have here, line 22. Cross-undertaking and damages. This is Miss Hannaford. Can I just be clear about this? As I understand it, neither IGT nor Camelot are offering a cross-undertaking for the losses to good causes. And I understand from their submissions that that is because they are not losses suffered by my client. And I explained to your ladyship yesterday that they are not losses suffered by my client. But as your ladyship will see from that table, and I think that's the table at 50,
Yeah.
they are extremely large losses, and they're a factor in my submission to weigh in the balance of convenience. So it was there. It's always been clear that it's our view that good causes are not part of an undertaking, because, as my learned friend Mr. Coppell said, they're not suffered by either Allwyn or by the Commission. Your Lordships have drawn from Mr. Coppell the position, what if we think it ought nonetheless to be? But that has not been canvassed before.
So it came in, the good causes undertaking came in as part of the actual discussion about whether the suspension ought to be continued, which would be if you got permission live on the appeal. And so I suppose you'd say, well, we shouldn't be here today prejudging that point.
My Lord, no.
But it would be open to the respondents to any appeal to say, actually, whether by way of respondents' notice or otherwise, if good causes aren't covered in a cross undertaking, then the suspension shouldn't occur. I should be lifted.
They could. I mean, it is apart from the unfortunate timing, my lords, it is in a sense a good thing that this is coming out in this way. In the ordinary course of things, one might have given an undertaking in the standard form. Something might have gone wrong, and then 2 years down the line, we might have been in court arguing about what is and what isn't loss.
Yeah, well, that was the point I made to Mr. Coppell, because,
Yes.
you know, loss is capable of a myriad of meanings depending on the context. So you're quite right.
So
if it was relevant to the balance of convenience,
yes,
that there wasn't an undertaking covering good causes, if the court endorsed the order in this form on the basis that you and Mr. Coppell both say it does not include good causes, then that point remains open on the appeal to the Commission.
yes, that must be right.
The Commission wouldn't be prevented from raising that if it was excluded from the undertaking on the basis that the court had endorsed the undertaking, the Commission wouldn't be in any way a stop. The point would be open to them on that basis.
Indeed, and that's entirely consonant, if I may say so, with the whole way that the debate developed below, where good causes were discussed, they were weighed, and indeed the court decided on the basis of them.
My Lord, can I just clarify one point? Yes, I mentioned undertakings in relation to the balance of convenience, but I also mentioned them in relation to the absence of an undertaking. If you look in our submissions, at paragraph 130 on page 44 of Supplemental Bundle 1, you'll see a heading H7, absence of cross-undertaking.
Yeah.
Neither Camelot nor the IGT claimants have mentioned their willingness to make a cross-undertaking in damages to meet the potential damages incurred by the Commission, Olwyn and or the National Loss Redistribution Funds.
Yeah, my understanding is that it's always been a point that you've taken front and centre.
Yes.
And in these submissions, on the application for permission to appeal, you say the absence of a proper undertaking is a reason why we should refuse the application for permission to appeal. So I don't think anybody could say that your position on the absence of undertaking has only emerged today.
No. I just wanted to make that clear.
Yeah.
Right, but my point was more that the fact that the suspension will give rise to reduced contributions, and we've seen the evidence of the calculation, was one of the key findings against us. One of the key reasons we lost below paragraph 153 of the judgment is because of the reduction to good causes. So if it was somehow thought that, well, an undertaking is going to cover it all, on reflection, it doesn't seem logical that we could have lost on that point. The reduction to good causes should have then been taken care of.
Well, that's the converse of the point I've just made. Yeah.
Exactly.
Yeah.
Exactly.
Okay. All right. Anything else, Mr. Moser?
Not at present, my Lord.
Now, does the first point in relation to parent undertaking apply to your clients or not?
But we are the parents.
So the answer is no.
No, I mean, one of the things about us is that it's never been in doubt that we're good for the money.
Could I, before the response, to just answer a couple of questions which my Lord asked me in the course of my submissions that I was going to get an answer to?
Yep.
The first point was the mechanism in relation to contributions to good causes. I'm instructed they do show on our balance sheet, and we have an obligation to pay them over to the distribution fund. I think it's license condition 11.
So there'd be an equal and opposite sort of liability, and an asset and a liability if you take a snapshot on the balance sheet. Yeah.
It shows as a debt on the balance sheet to the distribution fund.
Isn't that what I just said? I think I used the word liability. I'm sorry if it. I should have used the word debt.
I'm sorry, I heard the word debt shouted at me several times from behind. My Lord, the other question you asked me, I think, was about other authorities in terms of access to justice.
Yeah.
Not on the precise issue of a cross undertaking, but of course on stay pending appeal. There's extensive case law on the need to avoid imposing conditions which stifle participation in the appeal.
Yes.
And
of course, all of that, because we talked about that, that's all fine, but that mischaracterises where we are in this case. Because in this case, the both sets of claimants are seeking the indulgence of the court, because both sets of claimants are asking the judge and effectively the Court of Appeal to exercise their discretion to prevent something happening. And so it is the equivalent of an injunction, and in the old days was an injunction, and that's why American cyanamide applies. And in those circumstances, the undertaking is resolved at the outset. So you never get on to questions of appeal and stifling an appeal, because this should have been done, as I've said a number of times today, many months ago. So it isn't stifling the appeal, it is effectively whether or not the claims should be allowed to go forward without undertaking.
Well, I don't disagree with that. Simply to say, in form, what we're arguing about is whether the stay on the judge's order, which was then extended by this court until tomorrow, should be...
Well, that was because I was asked to deal with it in 2 days without having been given most of the documents and no authorities. So with great respect to Linklaters, I concluded that that was an unreasonable request, and so I extended it by a week. I'm sorry to have added to the delay, but I think that was a not unreasonable thing to do.
And the final point I'm asked to mention is, of course, the potential consequences of the cross-undertaking are related in significant part to the timing of the hearing of the appeal, which, when we initially made inquiries on this, we were informed that the court could accommodate an appeal in the last week of this month, and then we had the indication from my lord that it might need to be September. But in whichever form the undertaking is, if permission is to be granted with an undertaking, in whichever form the undertaking is put, we would respectfully invite the court to list the appeal as quickly as possible, and that will impact upon the consequences of the undertaking.
Of course. I mean, that's hence the update last week, indicating when, if permission was granted, when a hearing could be slotted in. Because, of course, the difficulty that you've got is that it's the vacation. So that's obviously an issue. Notwithstanding that, obviously, I've had various inquiries made. So we understand that point. All right, so Ms. Hannaford.
I think Ms. Davis is going to go first. That's all right.
Oh, okay, yes.
I was planning
fair
to
enough.
take
Yep.
the question of whether the only undertaking which we've offered, which is the one from Camelot UK and Camelot Global, is appropriate, and leave to my learned friend Ms. Hannaford the question of the good causes. So I'm just focusing on who's offering the undertaking.
Yes, this is the parent company point.
This is the parent company point. Now, my learned friend Mr. Coppell says that this undertaking is the undertaking which the learned judge had in mind in paragraph 125 her judgment. And with respect to him, we do not accept that. The whole debate before the judge about the adequacy of the undertaking that was being offered by Camelot was that the only party offering the undertaking was Camelot UK. Camelot UK, as you know, is a special purpose vehicle. The evidence before...
Well, the short point about Camelot UK is that the application for permission to appeal is based in part on the proposition that their business would be destroyed if what they say is the unlawful decision to give the contract to your clients was fulfilled. So if their business was destroyed, they wouldn't have any money.
Well, it goes further than that, my lord. Yes, that's one part of it, but it goes further than that. There was, in fact, evidence from Camelot UK as to the resources that might be available to it to satisfy a undertaking. We've summarised that, in fact, in one of the letters I referred to earlier, but it's the easiest place to take it. Take the supplementary bundle at page 753.
Yeah.
I mean, it's the same as the.
It's the up to 100 million. Now there may be debates about whether that's actually a correct figure or not, but the point is that was the amount that was identified by Camelot UK itself as potentially being available. Our criticism before the judge was that was plainly inadequate by reference to the potential scale of my client's losses if the suspension was maintained. And to give my lords the best reference in relation to that, where all the figures are, that's in Mr. King's second witness statement, paragraph 11.65 at page 506.
Sorry, give me the reference again.
Supplementary bundle,
Yeah.
tab 18, page 506, Mr. King's second witness statement, paragraph 11.6.5,
Yeah.
where the figures are confidential, but my lords can immediately see that just looking at the net present value of lost receipts to my client if there was a delay of 1 year, and recall that Mrs. Justice O'Farrell's view was that there would have to be an interim licence of 10 to 12 months, so that's where the year is, was that figure which vastly exceeds the 100 million that is available to Camelot UK. And as my learned friend Mr. Coppell rightly accepted, this wasn't a question of a capped undertaking.
Wait, sorry. 11.6.5. The figure in the fourth line is actually the net present value of the loss
Receipts.
to good causes.
No, our lost receipts. That's Allwyn's lost receipts.
Is that right? It says,
Contribution.
if the suspension is not lifted, the challenge dismissed, the expected increased contributions to good causes will be delivered with a 1 year delay. The net present value of that loss
Yes, that's the
is log. And then in addition, the net present value of our lost receipts would be a further log.
yes.
So I assume that the first figure is the net present value of the loss to good causes,
Yes.
and the fourth line, but the sixth line, the figure at the beginning of the sixth line, is the net present value of your.
Yes, and,
Right.
and that exceeds the 100 million.
Right. Sorry,
Yes, sorry,
I may have misheard. Sorry,
I'll take it too quickly, but that
Sorry.
figure on the beginning of the sixth line clearly exceeds the 100 million that Camelot UK's evidence was available to it to meet a cross undertaking.
Right.
Now, as Mr. Coppell rightly explained, there was no suggestion by Camelot UK that it should have a cap on its undertaking. To the contrary, Lord Pannick, in oral submissions, said Camelot UK are offering an unlimited undertaking, and this is the evidence we have as to its ability to meet it. And our point in response was, well, that's not adequate because it doesn't cover the likely level of losses. And when we then go to the judge's judgment at paragraph 124 and 125 at paragraph 180, you see the learned judge recording that I was concerned that they hadn't offered an adequate cross-undertaking guarantees, seeking to limit their exposure pending provision of further details of anticipated losses. That's reflecting the fact that the only amounts that were being put forward as available to meet the undertaking were the 100 million, which the evidence came from, was available to Camelot UK. And the debate before the judge was exactly the debate that I'm now seeking to raise, which is that's not good enough, because in practice, that is not unlimited. And that is the point that we expressly made, if we go back to the supplemental bundle, page 753, on Monday of this week, again, in response to my learned friend's reliance on the fact that Lord Pannick had already offered an unlimited undertaking from Camelot UK. We said, again, that's not in practice an unlimited undertaking at all. And insofar as we need authority to support that point, in the section of the White Book, which my learned
Authorities
friend...
to support what point?
Well, that it's not sufficient to say, in theory, that it's an unlimited undertaking, but if the evidence shows you that that's not actually in practice an unlimited undertaking...
Well, it is an unlimited undertaking, you just say in practice it's
not adequate.
the grant assets to back it up.
Yes,
Yeah.
To which fortification is the normal answer.
exactly. And perhaps I don't need to go, but the next section in Volume 2 of the White Book makes it clear that that's a relevant part of the consideration of whether the cross-undertaking that's being offered is sufficient.
Yeah.
It's paragraph 15.30 of the notes.
Okay.
Now, the one thing that has changed since the position before the learned judge is that we're now being offered an undertaking by Camelot Global as well. But lest it be thought that that makes no difference in practice, its accounts were in the bundle before the judge, and I can tell my lords on the basis of that its accounts of 2021 showed that it had made a total profit of 4.2 million, and its net assets were 23 million. So the addition of Camelot Global does not result in an adequate cross-undertaking in damages, even just looking at my client's potential losses here.
So give me the reference again.
It's Camelot Global's accounts. They're in the exhibit to Mr. Tanner's third witness statement, which are not in these bundles.
Oh, okay.
But I'm taking the figures from those accounts. So net assets 2021, 23 million, total profit 2021, 4.2 million. Now, I apologise for going to that. The difficulty is we have been raising this for a long time and we've had nothing, no responses to the letters. So that's why we're having to do it today. Now, my learned friend, Mr. Coppell, sought to explain away this fact, the fact that the parent undertaking was not supporting the undertaking or providing its own undertaking, on the basis that there were difficulties with advising the parent company, given that the figures, for example, that I just showed you in Mr. King's second witness statement are confidential. I have two answers to that. The first is that it's notable that my learned friends have never cited any authority to support the proposition that a party being required to give a cross-undertaking has to have quantification as to its potential liability under that cross-undertaking before it decides to give the cross-undertaking. Has to have visibility as to what its potential exposure might be. And indeed, insofar as we are aware, there is no such authority, and to the contrary, there is in fact a judgment of Mrs. Justice Cockerell at first instance saying that is not the position, which I can show my lords if it be useful. The second point, however, is a more practical one, which is we did agree on the 31st of May to let 3 representatives of the Ontario Teachers' Pension Plan into the confidentiality ring on condition. That is a letter to which we, again, did not receive any response. So it really doesn't lie in my learned friend's mouth, we would submit, to say that there's a problem here because we can't take instructions in relation to proper instructions from the OTP because we can't give them the information they require. And that can't be an answer to this. That's all I wanted to say in relation to Camelot. In relation to IGT, the position is still, as of 5 to 4, no undertaking. My learned friend, Mr. Moser, asked for the indulgence of the court to wake someone up in Canada and to try and get instructions. But we submit in reality here that it is far too late. This is not a new point. I've shown my lords the correspondence since the judgment of the judge. It was a live point before the judge as well. And really, we would submit enough is enough, and the application for permission to appeal by IGT should be dismissed on that ground alone.
Thank you very much.
My Lord, obviously I adopt and endorse everything my learned friend says there. No undertaking at all from IGT, but definite confirmation from IGT that there will be no undertaking in relation to good causes.
Yeah.
Inadequate undertaking from Camelot UK and Camelot Global, for the reasons my learned friend has just explained. Mr. Coppell says instructions could be taken about good causes, but this is, what, 2 months? More than 2 months after proceedings started. And anyway, I ask to what end in relation to good causes, given that the undertaking offered so far is nowhere near enough to cover Olwyn's losses, let alone good causes. And so I endorse that it is now, my learned friend's submission, that it is now too late and permission to appeal should not be given in this remarkable situation where adequate undertakings are not being offered at this stage. They should have been offered long, long, long ago, and many letters have been unanswered. As to good causes...
As to that, I mean, obviously it follows from what I've said earlier. I agree with that as a matter of principle. What about the position, though, that the figures, in general terms, are hair-raisingly large?
Well, my lord, I understand that they're hair-raisingly large.
I mean, the ones in the table, for example.
The ones in the table, yes. My learned friend obviously took your lordships to the most hair-raisingly large, which I think on current analysis is not in any way likely to be
I
relevant.
follow that. I was going with my lord's reference, which I think is more apposite to the paragraph above the table.
Absolutely.
And that figure is also
My lord,
hair-raisingly large. Obviously, there's a scale, but up to which one's hair would expand. But it is still a very big figure. That does not excuse, and I don't begin to suggest it does, that the failure to sort this out and the slight duvet over the head approach that it might be said has been taken. On the other hand, the court might say, well, that there comes a time when there is a risk of stifling.
well, my lord, but that is where, and it isn't satisfactory, of course, from the point of view of the Commission's statutory duties or the good causes themselves, but that is where it might be necessary to impose a cap in relation to good causes. But again, I say to what effect? Because Mr. Moser for IGT has made it very clear that he is not going to be instructed to give an undertaking in relation to good causes, and Camelot cannot, because they don't have enough money. Whatever cap you put on it, it's not going to cover Olwyn's losses and even a reasonable amount in relation to good causes. So in my
although that's subject to Ms. Davis's point about the parent company guarantee.
Well, my lord, yes, but here we are on the, what is it, the 14th of July?
Shout at me, Miss
But my lord, Miss Davis and I are slightly bored of making these points. I accept we haven't made them to you all that often, but we were making these points on the 11th of May and earlier, and they were going unanswered. And it is no good, in my submission, for my learned friend Mr. Moses to say he can't wake his client up. His client has had since before the 11th of May.
Yes. Well, I understand.
And as to the parent company guarantee, it has been raised many, many, many times. And the answer is nothing. It isn't, oh, I didn't know about it, or we've asked and we don't know what the answer is. It's just nothing. And in my submission, my lord, in this litigation, which my learned friend Mr. Coppell says is so incredibly important to his clients, it is, in my submission, astonishing that this is the position we are in. And there should be an undertaking in relation to good causes. I completely accept your lordship's point that it might need to be capped. But as I say, to what end? Because that will not, on what the position is at the moment, that will not help. Can I help on the question of the body in question? Because I think we can get a bit of assistance from the Act on this, which is in the Authorities Bundle, tab 1, page 3, section 5, subsection 6.
Sorry, this goes to...
So who the body is for good causes payment. Because there is reference, obviously, in the evidence to 12 funds, but the way it works, as I understand it, is that there is a National Lottery Distribution Fund to which you see reference in section 5, subsection 6 on page 3. And so it says a licence under this section shall include a condition requiring the licensee to pay into the National Lottery Distribution Fund sums out of the proceeds of lotteries forming part of the National Lottery. And then my understanding is that that is distributed by the fund to the 12 funds. Okay. So, and of course, my clients, have the overriding duties to, if they're setting up a national lottery, to do it in accordance with Section 5. So we have to set up that condition. So it's part of our responsibility, even if it isn't our actual financial loss. But in my submission, that's the body. It is a proper subject for an undertaking. There is no adequate undertaking offered even at this very late stage, and that should be a reason for any application for permission to appeal to be refused, in addition to all the other reasons that my friend and I have identified in writing and orally. Now, there is one further point, which was raised by my clients in a letter of the 12th of July. I understand that this letter has not been responded to.
The 12th of July, is that in the clip?
That, for some reason, is not in the bundle. Can I pass a couple of copies up? Now, this letter has been written by my clients because of their concerns about their statutory duties, and it's in relation to the provision of a potential undertaking. And we said before the CUKL, Camelot UK, provides any undertaking, we request they explain to the Commission the arrangements it has in place to ensure the carrying on of an assumption of liabilities as part of the fourth licence application activities will have no adverse impact on your third licence activities or your ability to carry on those activities. And then in particular, incurring or discharging fourth licence liabilities will not have any adverse impact on the operation of the National Lottery or payments to good causes as part of Camelot UK's third licence activities. And bullet point on the next page, Camelot UK has access to sufficient financial resources to ensure that should it be required to undertake or discharge any fourth licence liabilities, Camelot UK will continue to have the financial and operational resources to carry on its third licence activities for as long as and in the manner required by the third licence. My Lord, that is an important point to our clients. It hasn't been responded to.
But what do you want me to do about that? Order that they reply? I mean...
Well, my Lord...
I mean,
no, in my submission,
all of these solicitors are far too busy writing letters to do any actual work. But, I mean, I can see that it's a point. I can't see that it's a point that's directly relevant to what my Lord and I have to decide.
Well, my Lord, it is all, in my submission, it feeds into the issue as to whether, even if your Lordships thought that otherwise there might be some arguable grounds for appeal, whether an appeal should be permitted, because these points are important. The undertaking offered by Camelot is unsatisfactory for the reasons explained by Ms Davis, but it is also unsatisfactory that this has not been explained, this has not been responded to. In my submission, it is simply another reason why this application should be refused.
But we're not regulators. How can we possibly form a view as to whether the effect of, or what the effect of requiring an undertaking in these proceedings is on Camelot's ability to continue to satisfy its licence conditions? I mean, you're the regulator.
My Lord, I'm not asking your Lordships to form a view on that question. I'm asking your Lordships to form a view that this application for permission to appeal should be dismissed on the ground of failure to provide adequate undertakings, in addition to the grounds that I argued before lunch.
Right.
Could your Lordship just give me one moment? My Lord, on the stifling point, can I just make one further point?
On the what point?
The stifling.
Stifling, yeah.
My Lord, access to justice is not stifled because there would still be, even were a very large sum in relation to good causes to be due, because there is still a damages claim. The purpose of this application for permission to appeal is to prevent my clients placing the contract.
Yeah.
If my clients place the contract, there's still a very, very, very large damages claim put forward by Camelot and IGT.
Are you good for it?
Yes, my lord, that was, not personally, that was a matter that was debated in front of the judge. And there were various letters written about inquiries, I can't remember the terminology now, but inquiries made from the Secretary of State and so on, and confirmation has been given, yes, that appropriate authorisations have been provided.
All right, thank you very much.
My lord, if I may be permitted one sentence, I've been asked to point out that if there were a capping of good causes, then that would, which is not something we understood to be in the arena, but then I would have to add that to the things I would need instructions on. But it's not the case that I haven't commented on the capping. I've just said we wouldn't give an unlimited undertaking, including any good causes.
Yeah, I understand that.
My lord, 2 short points in reply from me, if I may, to Miss Davis. The evidence on the £100 million, which she says is insufficient, is on page 540 of the supplementary bundle. And the evidence given by Mr. Haldenby on that page in paragraph 20 is that Camelot would have at least £100 million available in October, November 22, which was the date when it was hoped that the trial would be completed and the judgment would be available. It's not a once and for all figure. It's simply saying that's what we expect to be available then. Of course, today we're talking about an undertaking over to, in the first instance, an appeal hearing in 2 months or hopefully less time from today. So the very, very large figures which are being bandied about in terms of potential losses aren't for Allwyn, and the comparison with 100 million is not quite so pressing in the context of that delay. And the second point is Ms Davis said that her clients had agreed for Ontario Teachers Pension Plan members to be admitted to the ring on condition. She didn't say what the condition was. It was that they give a worldwide undertaking for 3 years not to be involved in any lottery competitions whatsoever anywhere in the world. That wholly exorbitant request was not...
well, that's one of the disputes to Mrs.
And that's
Justice
one of the
O'Farrell.
disputes.
We can't deal with that.
My lord, but the idea that we somehow have overlooked the fact that they're willing on condition.
Well, it's one of the many millions of points on which these parties disagree.
But that is why, again, I'm explaining why you don't have the parent company in the arena. That's the only purpose of the point. I'm grateful.
Okay. All right, well, we'll rise.
Live streaming remains on. Ella Braverman's out. Sir Ella Braverman is out of the race. Right? Right then. My sweet shop was up there. That's a frightening. Pay more than so lean, regardless of the concept. Regardless of the Spanish goes to the last two. So it's any more than some. But there's a thing last night they did. They went new candidates, and about 5% of candidates said they don't have a problem anymore. But 7% had heard of some completely non-existent candidate. But it is good to know. I have to say that the guy who stood then stood down to get that junior minister, I'd never heard of him, and I followed politics quite a bit. So yeah. Mr. Ward is joining you from the side. Mr. Ward is in the jurisdiction. That's a reason not to. Had his 9-week case. Oh yes, complete with COVID after week 5.
There's COVID on the case.
A few weeks off.
That case finished at least 2 weeks ago.
Exactly.
Yeah.
They don't do them like they used to.
The rest of it is 24-week case next year.
Gosh, yes, that. 24 to 28. I'm not in it. Where's the pity? But perhaps if it doesn't come in, our problem is I'm conflicted in a different track. Maybe I'm not many different, two different sets of things. Not be confused. Although, according to the
Hmm? A bit knackered. You had a holiday, haven't you?
No, I did have a critical case yesterday.
Oh, did you? Tell me. No, I'm very fed up. I have to do the holiday. Counting the hours.
No, I had a very nice 10-day holiday every day, of which I spent Sunday.
That's very good.
Yeah.
I'm not just yeah.
Worse than usual.
Yeah, well, at least the mental piece.
Yeah.
That was a shame.
Yeah.
Yeah, I just got used to working 7 days a week and no food. So, it's a bit hopeless. It's a lot.
Joe's had busy.
Yeah.
He's going on to learn to be a ski instructor. He's learned to be a chef.
Joe Brown. What's he giving out about? Yeah, well, I did a case against him. Yeah. Well, it doesn't seem very easy to do when you do it. And it just, I don't know, for me, it's just actually, we don't seem to be in many of the same cases recently.
No, I've actually done that quite a lot.
Right.
I think that's to sort of. Well, my impression is seeing you two.
Oh, it's not. Right. Yeah, well, we suppose we're going to. Well, Joe, he's going to Saturday. He's had enough. And I'm going to go on the 1st of August. But there's a bit to do before then, isn't there?
There you go.
We've got a case and it's so it's interesting. So, very nice. Where leave your tender?
I was at the Greek Island to go and figure.
How old are your kids then? Yeah. Are they still coming on holidays?
Yeah, they all come. Yeah, they range from 30 to 20.
Right.
They're all
30.
30.
And still came. Well, that's good.
So yeah, they all. I think my son lives in Australia, so he's not around very much.
Right. Oh, that must be quite tough. Oh, yeah. You don't get anything like it.
So yeah, they can all go out for cocktails. It's pretty expensive actually. They all drink cocktails. Yeah, I lived in Florence for 2 years when I was a student. I couldn't do
It's nice, isn't it? Very, very steep hill.
yeah.
It's not one to do in the middle of August. Yeah, we live in a little place in a little village just 10 kilometres away.
Yeah.
Has to be which is really lovely. Hill is a lot less steep. And the views are fabulous.
Have you woken up yet, old man?
No, that's me. And I think you left for August.
That's the thing.
Very nice. I might make it over there.
My son can't make it.
You shouldn't make any such assumptions.
His favourite line is, why go on holiday when you've got home? To which I think there are many answers, but he doesn't agree.
Is he a teenager?
He's 17. Yeah, so last year at school next time.
So it's not. This is not party central.
No. Not a relevant case. I must sort this out. For some reason I only have a diary only shows telephone appointments.
Yeah, time limit.
Hi.
Good 15 years.
Two kids? One of them was somehow
Yes. Good idea. I haven't seen it, but I've got 2 or 3 next week. Move to Tuesday as well. It's closing. I mean, we have to do it. Because then you can't raise it.
It's all right when it works out this way.
Yeah.
Right. It's a consequential hearing, but it's also good for she's got friends through
Monday doesn't really ought to be banned, because that is the end of the year. So were we mistaken?
well, we
We can just see who's still there.
I don't know, just quite missed this stage. It's a cartoon, it's about it's very long.
The road.
It's a cartoon as appeal for very
This morning, I looked behind.
That's dreadful.
puppies who
Again,
got rid of all of the toys. It's absolutely brilliant. So we're moving house. Quite ruthless about it. These ways of justification and going to the cancer submissions in writing. They're like cultural toys. There actually weren't. It was quite funny. It was the sentimental toys that they wanted to have. But ones we just hadn't let in.
It's getting the parties to write the judgment.
That's the end of that.
people come in. Between the
too tight to give him 23.
No, no.
So he's in the house.
Yeah, just finished.
So, yes, I know. Well,
What he means turns out
didn't go to
it's written not very much.
Oh.
No.
So what, he's trying to have a year off? I can see it here. I'm thinking about it myself.
Oh, nice.
Can't do any more of that. That's quite a lot. Isn't it?
Yeah, so one of these gets sabbatical every 5 years, and he's due his sabbatical next year. I don't know what he's going to do.
How long?
It's a month.
Be nice.
Yes, but I asked her.
Before the people were
I had another hearing.
you had one that morning at 8 or something.
Yeah, 9 to 10:30 and 10 to 10. Yes, we don't look at great. And they possibly don't do it at night. So it isn't great. Well, some years they seem to have I could do that. Maybe.
I'm off holidays. End of the month. Going to Spain. Yes, of course. All these forest fires. No. Well, 32 is manageable. Yeah, but it's here. Yeah. Over here, of course, railway tracks, tarmac roads melted. You would laugh at 32 police or Spain. I don't know why it is.
Oh yeah, my
So much. We're going to go on a boat. So I don't know where. The yacht. It is sailing. Imagine it has an engine. I've noticed it. Somebody else is going to be sailing. Yeah. Cool. Maybe they're different sorts of different fires. Are you going? With also a friend, son. My wife is Swedish, so she's going to the band on the back. Yeah.
we are extremely grateful to leading counsel for all parties for the clarity of their written and oral submissions. We have spent this morning dealing with the application for permission to appeal, and we've spent this afternoon dealing with the question of undertakings which we raised at the start of the morning. We will deal with the points in that order, but we make clear at the outset that we have not forgotten and by no means underplay the importance of the undertakings. But we start with the applications made by the Camelot companies and by IGT for permission to appeal. The principal test is therefore whether the grounds have a real prospect of success. That's Rule 52.6.1a. That is a relatively low threshold. Having considered the documents, having heard all of the arguments, we have concluded that the applications for permission to appeal made by the Camelot companies have met that threshold in this case, and therefore, subject to other points which we shall come on to, we grant them permission to appeal. On the face of the material, we are less persuaded by IGT's submissions. However, we have concluded that they too should be granted permission to appeal. There are two specific reasons for that. One is that we do not consider that it's appropriate at this stage to grant permission to one group of claimants and to deny it to another when some, at least, of the challenges overlap. The second point is that we are persuaded that there is here what Rule 52.6.1b calls, quotes, some other compelling reason for the appeal to be heard, close quotes. Now, why do we say that? Well, first, there is a dearth of appellate guidance on the correct approach to applications to lift the suspension or to maintain the suspension relating to the award of contracts where the procurement process has not been challenged. And in our view, the arguments both this morning and indeed this afternoon demonstrated the absence of that guidance. We acknowledge Ms. Halliford's point that the procurement bill does set out guidance on this issue, which uses different words and terminology from those currently used by the courts. But it by no means follows that the actual test to be applied by the court will be very different to that which it currently applies. And that assumes that the bill is not amended further. So we do not consider that the opportunity to give guidance is an academic exercise. In addition, on the some other compelling reason point, it is important to be realistic. It is impossible for us not to acknowledge the significance of the fourth licence to run the National Lottery, which lies at the heart of the case, and the millions of pounds which the lottery provides each week for good causes. That also suggests that these issues should be tried at a full hearing. In consequence, therefore, of the importance of the procurement exercise, which is at the heart of this application, this will become a flagged appeal. And that means that it will be heard by the Master of the Rolls, possibly sitting with both of us. The appeal cannot be got ready and heard before the end of term, and of course that then means the start of the vacation. But we have liaised with the Master of the Rolls. He is conscious of the urgency of any appeal in this case. He is therefore prepared to sit on the appeal in this case during the week of the 12th of September. So the appeal will be listed provisionally for 2 days that week, and therefore to start on Tuesday the 13th. That will have the added advantage that it will allow at least most of the work on the judgments to be concluded before the start of the new term. We are conscious that in making that ruling and identifying that date, we have not inquired about matters that would normally be important, such as the availability of counsel. We know that a warning, as it were, was sent out last week, but we would have preferred, obviously, to go through the usual courtesies. I hope that everyone will understand that in this case that is simply not possible. The urgency is such that this has to be dictated, in this instance, by the availability of the Master of the Rolls, and to a lesser extent, the availability of my Lord and myself. Consequential directions, therefore, to lead to that point, will be that the respondent and the interested parties should serve their own skeleton arguments in answer to the full skeleton arguments from the appellant by 4 p.m. on Friday the 29th of July. That is so that those can be interleafed into the existing bundles, and those bundles possibly taken away on holiday by those judges lucky enough to be doing the case. It may also be, when we come on to say what we have to say about the undertakings, that both the respondents will wish to put in short respondents' notices dealing with two of the points that arise in relation to the undertakings. If they do, then again, Friday the 29th of July would be the date by which that should be done. As I've also indicated, the existing bundles which we have should be used for the appeal hearing, and any new documents, such as the respondent skeletons, should be interleafed and numbered accordingly. We then come on to the separate applications to continue the suspension that prevents the Commission from entering into the fourth licence with Orwin. As we made plain this morning, those applications have been fundamentally flawed as a result of the failure by the Camelot Group and by IGT to provide the usual written cross-undertakings as to damages. And we have, during the course of this hearing, expressed our surprise and disappointment at the absence of those undertakings, and indeed then the points of detail which we have been asked to consider this afternoon. Moving on to those then, the position is that a draft of the proposed undertaking was provided this afternoon. We accept the wording of the undertaking, and that is the undertaking that needs to be provided by Camelot Global, and by the IGT companies by 4 p.m. tomorrow. 2 points have been raised as to the inadequacy or potential inadequacy of those undertakings. Although the matters have perforce been dealt with relatively briefly, we have effectively been asked our views on those 2 points, and so we now give them. In relation to the undertaking as it presently exists, on behalf of the Commission, Ms. Hannaford points out that it does not provide an undertaking in relation to the losses to the good causes that would be caused if it turns out that this challenge fails. It was clear from Mr. Coppell's response that it was indeed not intended to cover that potential loss. It seems to us that the position is therefore logically this: we do not require the wording to be amended so as to include coverage of good causes. That is a matter for those giving the undertaking, that's to say Camelot, Camelot Global and the IGT companies. If the wording stays as it is and so excludes the good causes, then both the Commission and Allwyn are fully entitled to rely on that point as justifying their submission that the undertakings are inadequate, and that on the balance of convenience the suspension should be abandoned. We consider that that is an arguable point and should not be removed from the armoury of the Commission and Allwyn, the interested party. So we do not require the undertaking to include that. We can't in the present circumstances because there's simply not enough time, but it is a point that is open to both the Commission and the interested party at the hearing of the appeal in September. The second point raised by Miss Davis on behalf of the interested party is that the undertaking, although properly unlimited on the face of the undertaking, may be insufficient in practice. And this argument relies on a submission that on the evidence there is 100 million available to Camelot, and that the addition of Camelot Global doesn't make much difference, whereas the losses on the evidence as a result of this failed challenge may be twice that. We understand that argument, but on the face of the evidence, the 200 million would appear to relate to a much longer delay than, at least in the first instance, is going to arise as a result of us granting permission to appeal. In other words, that it won't be anything like a year delay as a result of that decision. So therefore, it's not obvious that the amount won't be enough. The related point is this. It does seem to us that it would be unreasonable to expect the trustees of the Ontario Teachers Pension Fund to enter into a parent company guarantee without knowing the figures. It is not for this court to get into the rights and wrongs of the separate arguments about the confidentiality ring. That is something that Mrs. Justice O'Farrell will consider in a week or 2 weeks' time. So again, the question of the parent company guarantee is not something that this court requires today, but again, at the hearing of the appeal, it is open to Allwyn and the Commission to argue that the undertakings are inadequate as a matter of the figures, and that therefore, as with the good causes point, they can argue that the appeal should be dismissed on the basis that there is inadequate covering of the potential losses one way or another. So that is how we propose to deal with those 2 points. In the circumstances, it's not possible for us to take those points any further. However, I should make this clear, because because of our ruling on the undertaking, that we are not requiring any changes, it follows that these undertakings in this form must be given by all of the relevant parties by 4 p.m. tomorrow, because that is the time when the suspension runs out. The suspension will not be extended further if those undertakings are not provided. My Lord reminds me that if the undertakings are given by 4 o'clock, the suspension is continued and would be continued to the second day of the appeal.
My Lord, one small point in my Lord's reasons just then, my Lord referred to a figure that is actually confidential and within the confidentiality ring.
I understand that, but we can't make sense of the point in open court without putting the figures in.
Well, with respect, one could, I'm not sure if my Lord is going to be producing reasons, because one could simply say much larger or larger.
It doesn't convey, it's double. I could say double. But
that still gives the figure away.
I understand that. Much larger doesn't convey the point that one wishes to get across. That's the trouble.
Well, it has been agreed that that is a figure that was in the inner confidentiality.
Yes.
So, I have to stand and raise and ask if there is a way in which, if my Lord's going to produce some reasons, it could be expunged.
From the, well, it can be expunged from the transcript. So what's your choice of wording? You don't want reference to the 100 million?
The 100 million is not confidential. But because Lord Panic referred to that in open court, but my figure is, so I've simply say much larger.
Fine, all right. Well, fine. For the transcript then, we'll say much larger as opposed to
the actual figure.
Well, if the 100 million is not confidential, we don't need to hide that. So we'll just say much, just one much larger.
That's how I put it already. So that's
fine.
I'm grateful.
Okay. So is that right? Yeah. Fine.
My Lord, if I may just also clarify, in relation to my Lord's order, if only IGT does not provide the undertaking by 4 p.m. tomorrow, because at the moment it looks as if Camelot will, what are the consequences in relation to the suspension? That's going to be a matter that's very important to my client, obviously.
Yes. More policing. What do you say should happen?
My Lord, I'd certainly say IGT shouldn't have permission to appeal in those circumstances.
Well, that I follow.
But given what I'm just thinking on my feet, given what my Lords have said about Camelot's position, then the logic, I think, would mean that Camelot's appeal could continue and we would be able to bring respondents' notice points about their adequacy of their undertaking.
Yes. But you don't say if IGT don't provide the undertaking, then you say the consequences of that would be they can't appeal.
Yes.
But you don't say the consequences of that is that you could enter into the 4th licence.
Well, because as I understand my Lord's ruling, my Lords have decided that the undertaking that Camelot are offering are sufficient from the Camelot parties, and they've identified a proper ground of appeal, and therefore my Lords are saying in relation to permission to appeal, but suspension should.
Yeah, no, I'm just making sure that you're not saying that.
Well, that my Lords would be staying paragraph 1 of Mrs. Justice O'Farrell's order, I believe.
Mr. Davis, I wonder if that point is met by making it clear that each party, that's to say Camelot, Camelot Global and the IGT claimants, their respective permissions to appeal are conditional upon their respective provisions of the undertakings by 4 o'clock tomorrow.
My lords,
Does that mean any sort of joint and several point?
from our perspective, I mean, obviously, we would have wished for a different result in relation to Camelot, but given your ruling, we are where we are, so yes.
Fine, all right.
Mrs. Hannaford can see a problem with that.
Yeah, no. Ms. Hanford, you,
Well, no,
Does that
I
deal
mean,
with
no,
the-
I can't think of another solution to the difficulty. No.
no, okay.
Could your lordship give me a minute to just confirm? My lord, regrettably, I'm not going to make any further submissions. But thank you for your indulgence.
It's all right.
My lords, I have a much more prosaic point, if I may.
Yes.
Provided the undertaking is given by my clients by 4 p.m. tomorrow, may we by 4 p.m. on Monday serve a very slightly amended skeleton argument, mainly to correct some obvious typos, also partly to reflect some of the cases and points I made in oral today, so that I don't have to repeat them in oral at a substantive hearing in relation to ground one. We did say when we lodged it that it was drafted in
Yes.
haste, and
Well, of course, but all of this is in haste, and so it's just, I mean, what I'm anxious to do is to have all the key documents in place so that they can be taken away
yes, but
by me, amongst others. So
this would be by 4 p.m. on Monday.
If you're saying 4 p.m. on Monday, subject to any view my lord has, my lord is not overly concerned about giving you till 4 p.m. to do that. I mean, any changes need to be kept to a minimum.
There will be no surprise.
Skeletons are helpful because they indicate what the points are going to be. So
It would be essentially a tidying up and putting it in line with what I said today.
yeah, okay.
I'm most grateful. And may I express, probably on behalf of all of us, how grateful we are. The fact you've taken all day and sat until now.
I told my clerk it would be all day, and I told him that knowing who was in it, but it wasn't as a result of who was in it that led it to be a day. I mean, these things are difficult because you're having to do a lot of difficult things in a short period of time. I get that.
And matters
But
arise. But as I say, we are grateful. It does not go unnoticed or unmarked.
Well, I asked my lord personally if he would mind doing this with me today, and he graciously agreed. So that I would have done it anyway, but your thanks should go to him, because he's been a huge help. All right, so that's that. Any other points to clarify?
No.
Or to... All right, can you draw up an order? I think that would be the best thing. You've got a transcript, so I wasn't proposing giving you anything else. That's it in terms of what we've done today. You can draw up an order summarising the order parts of what I've decided, what we've decided.
My lord, yes.
All right?
And my lord, the cost will be in the appeal.
The cost will be in the appeal. Yeah. If you think we're arguing about the cost, you really do have another thing coming. All right, thank you all very much.